Hi, my name is Robert Chelle with Chelle Law, and my law firm assists dental associates with employment contract review. Today, I'm going to talk about dental associate contract red flags. So, there obviously can be dozens of red flags in a contract. However, there are kind of a handful that are absolutely necessary to take a solid look at and kind of go over those. So, the first thing would be no without cause termination. So in any employment contract, there's going to be a section called term, which just means how long the contract is, and then termination, how the contract can be terminated. Contracts can be terminated a number of ways. The term could just end and it's not renewed. It could be terminated by mutual agreement. It could be terminated for cause. So if one of the parties breaches the contract, doesn't fix the breach, the other party generally has the option to immediately terminate the contract. And then the last way, and most important way, is without cause termination. So this just simply means that either party can terminate the agreement at any time with a certain amount of notice to the other. So normally somewhere between 30 to 90 days. The reason why this is important, and I find this especially important for dental associates for whatever reason, without the ability to terminate the contract at any time. So like, let's just say the dental associate has a 2-year contract and they cannot terminate without cause. You're essentially stuck there for 2 years unless the other party breaches the contract. There are plenty of scenarios where if a dental associate is on some kind of net collections, volume, compensation, the owner will generally, I'd say, overestimate what the associate will actually make. And so they can get into a job if they're not paid a daily rate or a salary. It's more of just eat what you kill. You get a percentage of whatever's collected. And the volume simply isn't there, and you're not making nearly as much as you expected. You still would have to play out the rest of those 2 years. And that is a situation no one wants to be in. So first thing, absolutely make certain there's without cause termination at any time. Sometimes the employer will try to say, well, you can't give notice in the first year, or you can't give notice in the first 6 months or whatever. No, anytime, if you start, give notice, you do your whatever the notice period is, move on. Absolutely necessary. 2, compensation. If you are a dentist and you are being paid on either net collections, encounters, some kind of volume metric, and you are not 100% certain that the volume is there for you, you need to be very careful about taking that job. A daily rate or a base salary, especially in the first year or two, insulates the dental associate from just getting completely screwed by an employer that is, I guess, unwilling to make some kind of income guarantee, and then is bringing in a dentist, but in that circumstance only has to pay them based upon some kind of, volume metric. Just like in the example I just gave, if a dentist starts and their compensation is based purely on production, and the production is completely out of their hands, right? They're not doing the marketing. It is on the employer to drive the business, and they're not. It's a problem. So for anyone who's new, maybe just out of training, or you're relatively new, it's fairly important to have some kind of guaranteed salary or daily rate. And then once you're there, and maybe you've been there a year or two and you see that the volume's there, maybe potentially you can make more under some kind of collections model, well then talk to the owner about switching. But at the very beginning, I find most places who try to lure dental associates in with big numbers, it almost never shakes out that way. Okay, so another big red flag is the non-compete. So this is one thing that varies state to state. Each state kind of has their own view on what's a reasonable non-compete. Non-competes are enforceable in almost every state. California, New Mexico, Massachusetts are three of the few states where they're completely unenforceable. But for most states, it has to be a reasonable length. So usually about 12 months. Sometimes they'll try to do 2 years. And then some kind of reasonable geographic restrictions. So usually somewhere between like 5 to 15 miles. If you have a 5-year, 50-mile non-compete, that's crazy. You do not want to sign something like that. You want it to be no more than a year, and then no more than, I would prefer, 10 miles from your primary practice location. Many of these big corporate dental offices that have multiple locations in the area will state it's 10 miles or whatever the geographic restriction is from every place they own, even if the dental associate didn't provide care or work in that location. No, can't agree to that. It needs to state that it will only apply to the locations where the dentist actually provided care. And even then, try to limit it to no more than 2 locations. In these really big cities, obviously, corporate dental conglomerates continue to gobble up some of the dentist-owned practices. And so if someone has 10 locations in a city, and it's 10 miles from 10 locations, you're going to be knocked out of your city. So what's in the non-compete is certainly important. And then last, and just I'll touch on this briefly, the benefits. So if a dental associate is an employee, the employer should pay for your license, DEA registration, continuing education. If you're moving from out of state, some kind of reasonable moving expense reimbursement. These are normal things that an employer should pay for. So think about that as well. Anyway, hopefully that's helpful. If you have any questions, you can always call my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com, CHELLE law.com. And I appreciate you watching the video. Thank you.